Hello, thanks for joining me. Today's video is a step-by-step description of the estate planning, signing, and execution process, giving you some idea on what's required to make wills and trusts and powers of attorney and those kinds of things legally enforceable and fully effective. Before we get into the documents themselves, I just wanted to give you an introduction to some of the baseline requirements for a proper signing. One of those, of course, is that the signor, the person in executing these documents, be lucid and able to understand the basic provisions, what's being done, not necessarily every single word, but have a general idea of the purpose of their signing these documents. Along those lines, we don't want a situation where there could be an argument of undue influence, so we don't want anyone other than the signors to be involved in the signing, other family members, anyone who might influence them or push them in a certain way or even be perceived to have done that shouldn't be involved at all. And you do want to document that that's the case. So if someone did show up, you keep them out in the waiting room, that kind of thing. Also, we'll need, if we're talking about wills and trusts, at least 3 witnesses to be involved, one of which being a notary public. We'll get into exactly which documents require which persons and in which order and so forth, but that's kind of the baseline that we'd require. And the witnesses should be disinterested, not named in the documents as beneficiaries or fiduciaries. They should just be maybe staff members of the law firm, what have you. And most importantly, probably, is that everyone must sign at the same time in each other's sites and presence. So there's no signing at different times or locations, or the testator putting their signature and then later on somewhere else a witness signing. Nothing like that. Everyone should just be in the same room watching everyone sign simultaneously. And normal signatures, your usual signatures in ink, are going to be fine from our standpoint. Obviously no pencil, but if somebody's signature looks like a scribble and that's their normal signature, that's fine. Doesn't have to be in any particular manner. So scrolling through, if there is a living trust or different kinds of trust, that's usually going to be the first one up. That would be signed generally before the will, for instance, because a lot of times the wills refer to the trust. So the trust signs get signed first, and you'll see right on top here who the settlor or creator of the trust is, who the trustee is, oftentimes one and the same. These might be joint trusts for a couple, perhaps, so you'd see 2 names there. Sometimes an additional trustee would be named from the get-go, but usually the settlors are taking care of business in the beginning. You have the name of the trust, and then in this area, section 2C, you'd be seeing who the successor trustee would be. So if the ones listed above couldn't handle that role, then these one would step in under those circumstances. By this time, the testator or the trustor or the settlor would have already read through really all of these provisions and referred those and reviewed those with the attorney that drafted them. So it's not something where you have to go through each and every provision. The trustee part is important. And the other parts, as far as distribution, are going to be important as well. We like to review those again, what happens when someone passes on, what their wishes are in those circumstances. So it's good for the client to take another look at that to confirm that they have the right gifts and bequests and devises to the right people in the right order and all that kind of thing. And then the actual signing, we would put in the date, and then the settlor creator would sign once here, and then usually again as the trustee, just wearing different hats. And then the witnesses would sign below that. So the names of the witnesses here, just in print, the signatures of the witnesses, and you can print again just for clarity. The address of the witnesses, office address would be fine in that circumstance. And then you'll have a notary block here. Sometimes there'll be a self-proving affidavit. We'll see that with the will in a moment. Sometimes it'll just be this attestation clause where they say person X, and we would fill in that name if it's not there, signed in the presence of, so on and so forth. And of course, that gets stamped, and that should take care of the trust part of it. If you have a trust, then you'd have maybe some funding documents like an assignment of personal property. That's about getting assets into the trust name. That usually just requires the property to be kind of generally transferred in there. There might be more specific funding documents that have to do with particular bank accounts and things, but as far as a general provision, or there might be personal property distributions that come with this. So my gold watch goes to my best friend or whatever that might be. That can get written in there. A lot of times this gets left blank because those wishes aren't known yet, and they can actually change this down the road without witnesses or a notary. So it's a nice convenience for those tangible personal items. It's really the one thing you can change without all those formalities. So that's helpful in some circumstances. And then we come up to the will. Pretty much everyone's going to have a will. If you do have a situation where there's a trust, the will would usually make the trust the beneficiary of the will. Or if you don't have a trust, then this would really be the centerpiece of the planning. And you see here some name of the testator, their family situation, who's going to be the personal representative after they've passed. Maybe the same people wearing different hats here. There may be alternates. There may be people working together perhaps as co-testators. That's fine. And then in 3B, in this case, you're going to determine who gets the rest. And because we have a trust, the trust is kind of the final beneficiary here. If there was no trust, you usually see some names or charities or institutions that would receive all of that. And then you can basically skip down to the execution portion here, where you have the same sign-or, signing once, and then the witnesses, two witnesses, disinterested individuals signing as well. And then you'll see this affidavit. So the self-proving affidavit is really where we need the third person involved. So we have the testator who signs again. We have the witnesses who sign again. And then we also have the final person who notarizes everybody's signatures, taking the oath of all three of these above and just basically stating everyone was there, signing at the same time in each other's presence. So the self-proving affidavit, which again may also be included with the trust and definitely would with the will, is where you really need those three people. And when you get to the rest of the documents, you only need two people to step in. And so you can get one of the non-notary witnesses and peel them off because you only need two moving forward. The power of attorney is for property and financial decisions. It is immediately effective, so right away, the persons that are listed here are going to be able to step in and pay bills and take care of financial decisions and so forth. And it does remain in effect even if there's an incapacity. That's what makes it durable. There may be alternate agents and so forth. And then there's just a whole laundry list of different powers that come into play. Each one that's initialed, and there's a lot of them, are powers that are being authorized. If someone's uncomfortable and doesn't want to initial something, that's perfectly fine. But generally, they'd initial all of the above to make it as broad as possible. And then you get into the execution portion on the power of attorney, which just involves the one signature, also two witnesses, kind of sensing a theme there, and a notary as well. But the notary, again, can be one of the witnesses in this circumstance because they're just notarizing the signature of the principal here, not of the witnesses, so not of themselves. So that will have a valid execution. And then the next up that you'd normally see is a health surrogate, which is similar to a power of attorney, but it's for property and, it's for health decisions. So who would talk with your doctor, who would help with a procedure in a medical emergency. They're going to initial these two right here in all circumstances. Those are the basic powers that are being authorized. They might have organ donation wishes, or maybe not. If not, they can just leave that blank. And then these two here towards the end are optional, but usually good to initial. They would make these two powers immediately effective if they're initialed. So this first one is to say, my surrogate can immediately get health information. And the second one is to say, my surrogate can immediately help make decisions for me and my health care, rather than waiting for an incapacity to trigger these. So if they don't initial these, those powers will still come into play, but only when the principal is out of commission, incapacitated, that kind of thing. And this one just needs the two witnesses to sign off on it, to agree and acknowledge that they were there. There's usually a notary block that goes with that as well. And similar to the power of attorney, the notary can also be one of the witnesses. No problem there. A living will is usually what we'd see next. We're not naming anyone here. We're just saying what we want to have happen in these conditions. So if the person's incapacitated, they're terminal, end stage, persistent vegetative, and the doctors don't feel like there's any hope, they're saying they don't want artificial life prolonging activities to continue. And so they can initial one, two, or all three of these. Most people initial all three to make it as broad as possible, but that's up to them. We have the two witnesses again, and then perhaps a notary block to go along with that. Notary can be one of the witnesses. And then usually last up is going to be the final disposition wishes, cremation, burial. Sometimes they'll check that box. Sometimes it'll be pre-populated. And there may or may not be any particular wishes about where their ashes might be spread, that kind of thing. Do they want a funeral? Who's going to be stepping in to make sure that that's done properly? And any other wishes that they want to add to that. They sign it, got the two witnesses again. That's really all that's necessary on that. And pretty much that's going to cover the baseline documents. You might see some different ones in there. There might, again, be particular funding documents for a trust or what have you. And there are also some considerations after the signing. So once it's signed, sealed, and delivered, really none of these things have to be recorded or registered anywhere. A will only gets deposited after somebody dies, and the rest really remain private. So you want to instruct the signors to keep their original documents in a nice, safe place, but also accessible. So when the time comes, people can get their hands on it. Maybe not a safe deposit box, because those are hard to access after someone's gone and people don't always know they exist. And it's a good idea these days to scan all of the fully executed documents into a PDF. You can email that to the clients. They can forward that to the successors if they choose. And usually you're going to want to CC the attorney that drew this up and make sure that everyone has a copy of this and it can be easily accessed in the future. If anything needs to be changed during the signing, a lot of times they can just sign it the way it is, and then a simple amendment can be added later or adjusted in some other fashion. But if anything does come up and there are any questions, of course, you can reach out to us, and hopefully everything goes smoothly. Thanks for listening. Take care.